I am Christina Henderson, Executive Director of the Montana High Tech Business Alliance. Welcome to our webinar, New Rules for Foreign Investment, CFIUS Compliance for Montana Tech Businesses and Investors. For a full schedule of virtual and live events hosted by the Alliance, you can visit mthightech.org/events. Today's webinar is co-hosted by the Montana World Trade Center and Montana Department of Commerce Export Montana. We will be recording the session and the video will be available on our website and emailed to everyone who registered. If you have questions, please type them in the chat box or unmute your microphone to speak. We also have a few questions collected in advance that we'll be sharing. So with that, I'd like to turn the floor over to Brigitte Miranda-Freer, Executive Director of the Montana World Trade Center, to introduce our speaker.
Thanks, Christina. Just a couple words first. As Christina said, I'm the Executive Director of Montana World Trade Center. MWTC is one of 300 World Trade Centers in 100 countries around the globe, and our aim is to grow Montana's international trade portfolio. And as part of that, our work is to spearhead the Foreign Direct Investment Initiative for the state of Montana. So to be clear, FDI has existed in the state of Montana for quite some time now. Pasta Montana is an FDI placement in our state. GlaxoSmithKline is FDI, ADF in Great Falls. There are many placements. And you can certainly visit our website to learn more about what exists in our state already. But as Montana's economy diversifies into more knowledge-based industries, whether we're talking about cloud computing, photonics and optics, or even bioscience, CFIUS will play a larger role than it has in the past. So it's really incumbent upon us to make sure that we understand the work and scope of this committee. And so to that end, I can think of no better person to explain it to us than Amma Adams. And I'll just share a little bit about her bio with you now, and then Hallie's also going to post it in our chat. But Amma, you're a rock star. She's an anti-corruption and international risk partner in the litigation and enforcement practice of Ropes and Gray in Washington, D.C., where she chairs the International Trade and National Security Group. Her practice focuses on international transactions and the U.S. government's regulation of trade and investment. This includes most notably FDI, export controls, economic sanctions, anti-corruption, and custom laws and regulations. In addition to advising clients on the application of international trade regulations to their business ops, Amma also assists clients in developing compliance programs, handling pre- and post-acquisition due diligence, conducting internal investigations relating to potential violations of trade laws, and representing clients before U.S. government agencies in connection with license requests, enforcement matters, and government inquiries. She also reps companies before CFIUS in national security reviews of foreign direct investments in the U.S. She advises companies in a range of industries, including tech, aviation, pharma, healthcare, manufacturing, chemical, and financial sectors. Amma, we are really pleased to have you here. Thanks so much for joining. Take it away.
Thank you so much for that lovely introduction and for the invitation to join you all this afternoon. As Brigitte was just walking through, the importance of foreign direct investment, particularly for Montana and businesses in Montana. The focus of this presentation is just to provide kind of a baseline understanding, excuse me, of what CFIUS is, kind of the process, the changes in the rules over the last few years, and then focus on some industry-specific considerations with respect to biosciences, life sciences, and biotech companies. So if we could kick off with slide 3. So, sort of laying the groundwork for what is CFIUS, the Committee on Foreign Investment in the United States. And it's an interagency committee that's made up of 9 different agencies across the federal government in the executive branch, including Department of Treasury, Commerce, State, Defense, Energy, Interior, and a few others. And also sitting on that committee is the Director of International Intelligence that helps CFIUS perform intelligence reviews. And really what the committee is focused on is reviewing foreign acquisitions and investments in U.S. businesses that raise national security issues. Oftentimes we hear from clients who are just coming up to speed with the CFIUS process, well, is this a way for the US government to control, all foreign investment to the United States? And what CFIUS will tell you, and what we have seen through our practice here in DC, is that CFIUS is very much focused on transactions or investments that do raise, material national security issues. And up until recently, as we'll discuss a bit later, the CFIUS process was exclusively voluntary. So it was fully within the discretion of the parties as to whether to submit a filing. Now, the most significant risk of not making a filing, particularly if a transaction does raise material national security considerations, is that the president can recommend that the transaction either be blocked before it takes place or unwound if the parties did not get clearance for CFIUS before the transaction closed. It's always important to remember that there is, excuse me, no statute of limitations for CFIUS to ask questions of the parties about transactions or investments that have not been notified to them. And in this context, over the course of the last 2 years, CFIUS has now set up an entire division or unit within the Treasury Department that is exclusively focused on contacting companies, investors about transactions that have not been notified to the committee, have not been brought forward to the committee under voluntary jurisdiction for clearance. And so we are, in our practice, seeing that kind of situation come up more and more often. If CFIUS has concerns about a transaction, they'll ask the parties to submit to a questionnaire. They might even, in fact, ask the parties to submit a filing after going through that questionnaire process. It's a group that's been very active. So as we're advising clients on the risks of not making a voluntary filing, we're always keeping that back in the mind that CFIUS still can come to the parties to get information and to seek or request that the parties submit a full form notice or short form filing to provide them an ability to assess the national security implications of a transaction or investment. Next slide, please. So again, historically, CFIUS has maintained jurisdiction to review acquisitions or transactions where a foreign person obtains control over a US business. So typically up until 2018, the paradigm was you were looking to see if a transaction sort of checked the 3 boxes that you see here on the slide. First, do you have a foreign person involved in the investment or transaction? A foreign person is typically defined to include an entity that is incorporated outside the United States and has its principal place of business outside of the United States. But we're seeing more and more situations where a foreign person can also include a US domiciled or US incorporated entity that is controlled either directly or indirectly by a non-US person, by a foreign person. So if a US business is looking to make an investment in another US business in Montana, and that US business has a foreign company that sits at the top as a parent, that US business that is considering the investment would be considered a foreign person because a foreign person would be able to exercise control over that US subsidiary. We also see situations more and more commonly where we have private equity investors who are looking to make investments into US businesses, and it requires sort of peeling back the layers of the general partner, the limited partner infrastructure or set up or framework set up within that private equity fund to determine whether in fact a foreign person is even able to exercise control, even if the private equity firm or fund appears to be based in the United States. So those are some ways where sort of this broad definition of foreign person can get a little bit tricky. In terms of the second prong, US business, you have to have a foreign person making an investment into a US business. And the US business is defined, again, very broadly, one that must be engaged in interstate commerce within the United States. And oftentimes we do have clients who like to try to argue that they are not a US business. So CFIUS should not have jurisdiction over a transaction involving a foreign person or a foreign investor. And it really requires scrubbing sort of the operations or the scope of operations that are occurring in the United States for that US business. If they have an office set up in the United States, if they have contracts with companies, even if they're not material contracts, that could be sufficient to be a US business. If the US business has a series of assets, which brought together allow it to be operated as a cohesive entity, that could be considered a US business. And then finally, assuming you have a foreign person and you have a US business, under the historical rules, you had to have control. So you had to have a foreign person who was able to exercise control over a US business through the investment or the transaction. Like these other prior definitions we've just gone over, foreign person and US business, control also equally defined as broadly. It's really whether the foreign person has the ability to directly or indirectly determine, decide, or cause important matters of the company to be executed. And CFIUS has within the regulations a set of 10 to 12 different types of parameters that would fit the definition of control. You don't have to have a totality of the parameters to find control. Just having one of those parameters on the list could be sufficient for CFIUS to indeed find control. And then CFIUS itself says that that list is not meant to be an exhaustive list. And so it really requires understanding the scope of the transaction and investment and making sure that the foreign person, when they say they're not able to exercise control, whether that analysis or assessment would actually meet the requirements of CFIUS in terms of this broad definition. And then you'll see there's a note there that there can be a safe harbor for transactions or investments using this paradigm. And really what that safe harbor means is that CFIUS would not typically have jurisdiction over a transaction where a foreign person's investment is purely passive and their level of investment is at 10% or less of voting interest. Now that is a very narrow safe harbor. You could have an investor who is at 9%, so you're under the 10% threshold, but they obtain a board seat or an observer right. So that's no longer a purely passive investment. So CFIUS could try to exercise control if they find other indicia parameters of control. And as I mentioned earlier, there's this new unit within Treasury that focuses on non-notified transactions. And we've seen a lot of pressure testing in the last year around companies using this safe harbor from CFIUS's jurisdiction. So one recent situation, it was an investment. CFIUS reached out to the US business who had taken on foreign investment. The CFIUS counsel on the US business side indicated that it was a passive investment within the safe harbor under 10% or less. I believe it was 3%. No indicia of control, and it took about 6 rounds of questions outside of a formal filing, but still 6 rounds of questions for CFIUS to get comfortable that the transaction was purely passive. So we always say to our clients, if we're going to use the safe harbor, we want to make sure to document that carefully in terms of the passivity, the 10% threshold, in case CFIUS does come and ask questions about that transaction. Next slide, please. So in August of 2018, President Trump signed into law what we call FIRMA, the Foreign Investment Risk Review Modernization Act. And it was probably the most significant change or expansion of CFIUS's regulations in over 15 years on a range of different areas, from jurisdictions, the types of filings, the introduction of fees, increasing CFIUS's scope of scrutiny into certain types of US businesses. I think for the purposes of this discussion, we'll sort of walk through some of the changes in the jurisdictional aspect with respect to CFIUS's authority. As I mentioned earlier, historically, CFIUS's jurisdiction was focused on foreign company, foreign investor acquiring control over a US business. But the US government in the last few years has become very concerned that there are a wide swath of transactions that fall outside CFIUS's historical jurisdiction that could still pose significant material national security considerations. Part of that concern from CFIUS perspective is, traditionally in the past, most foreign investors, most foreign acquirers were looking at control transactions where they were going to acquire the full scope of the US business. But over the last few years, we've seen very creative, novel investment vehicles and platforms, particularly in the private equity space, that US and non-US investors are using across the board for a range of reasons. And CFIUS became very concerned that there were loopholes in their jurisdiction around these points. And the traditional rules around controlled transactions still apply, but CFIUS, under President Trump's legislation and with significant bipartisan approval, pushed this legislation through, implemented new regulations, which really expands CFIUS's jurisdiction to look at what we refer to as non-controlling, non-passive foreign investment in certain types of US businesses, which we'll be referring to as TID US businesses. And that can include critical technology, critical infrastructure, and companies that collect sensitive personal data on US citizens. Next slide, please. So yes, under its expanded jurisdiction, CFIUS now has the authority to review non-controlling, non-passive investments in TID US businesses. So the T stands for critical technologies, the I is for critical infrastructure, and the D is for sensitive personal data companies. If you have a transaction where a foreign investor is going to be acquiring control over one of those three types of businesses, that would fall under CFIUS's traditional regime of looking at a control transaction. But now, if you have a foreign investor who is going to be getting certain rights that don't rise to the level of control, but gets certain suite of rights with respect to a TID US business, CFIUS could either have mandatory jurisdiction over that transaction, which means the parties are required now by law to submit a filing, or CFIUS could maintain voluntary jurisdiction, and it's up to the parties themselves to decide if they want to submit a filing for CFIUS to review. And the rights in question, again, these are rights that don't rise to the level of control, but they're certainly rights that are not passive from CFIUS's perspective. So if a foreign investor is going to be obtaining access to material, non-public technical information about the TID US business, that would be a sufficient right. If the foreign investor is going to be obtaining a board seat or an observer right, or even just the right to nominate someone to the board or to nominate someone for an observer right, that would be sufficient to provide CFIUS jurisdiction. And then finally, if the foreign investor is going to have the right to participate in substantial decision-making regarding the use or development of the critical technology, the use or development of the sensitive personal data around US citizens, or the management or operation around critical infrastructure that is maintained by the US business. If you have a TID US business and one, not all, just one of those rights, CFIUS can have jurisdiction. And in terms of the mandatory jurisdiction now, which is a new change from the historical rules, if a foreign investor obtains one of those rights with respect to a critical technology company, that transaction or investment must be submitted to CFIUS. Failure to make a filing can result in penalties up to the value of the investment or transaction. So this is a very new paradigm shift from what we've been used to dealing with in the last 20 to 30 years. So when there's a situation where you have a TID US business and a foreign investor, there's a lot of assessment from the parties, both on the foreign investor side and on the US business side, to determine whether a mandatory filing is at play, because no one wants to be in a situation where they miss making a filing that is required under the law. And then if the parties don't want to make a filing, oftentimes there is negotiations around the foreign investor perhaps forfeiting some of the rights that would provide it one of these non-passive, non-controlling rights would be sufficient. That would be sufficient to trigger the mandatory jurisdiction. So for those of you who've had experience dealing with what we call, CFIUS due diligence questionnaires from a foreign investor that focus on whether there's a TID US business, this is essentially what the parties are trying to understand very clearly and very early in the process. Is there a mandatory filing at play that the parties need to be considering? Next slide, please. So what is critical technology? For many, many years, CFIUS has been focused on, sensitive technology. And that is one of the considerations that it reviews when it's trying to determine if a transaction or investment by a foreign person creates material national security issues. But, CFIUS, all things CFIUS, there was not a lot of definition around certain of these core terms. With FIRMA, we now have this new term called critical technology. And the government has tried to give some framework as to what companies should be considering when they're trying to assess if they're dealing with critical technology. The first is, are any of the items that are sort of developed, tested, fabricated, manufactured by the US business, controlled for US export control purposes? Are they listed on the Commerce Control List of the Export Administration Regulations or listed on the United States Munitions List of the International Traffic in Arms Regulations? If there are, there is a high likelihood that those items would be considered a critical technology. And then council would have to go through some additional analysis to determine whether a mandatory filing would be at play. Underlying this definition is an understanding that the US business has gone through the process of classifying its items, its products, its technology, its software under either of these export control regulations. Oftentimes what we see is a foreign investor might be making an investment into a US business that has never had an opportunity to export goods, technology, or software abroad. So they haven't engaged in the export control assessment or analysis. And the US business may say, well, we don't export our technology, we don't export our hardware, our commodities overseas, so we shouldn't be considered a critical technology company. And the rule really does not require that an export or a transfer of data or a transfer of technology outside of the United States have to occur. The government has just determined that items that are controlled for export control purposes tend to rise to the level of a higher national security concern. And that is one of the basis for helping to determine if something is a critical technology company. The second factor would be whether the items are covered by the Select Agents and Toxins regulations. And that can come into play for different bioscience or life science companies that are involved in developing things around vaccines, different pharma products. There are certain types of items that are used in the development of those types of products that are highly classified or highly controlled, because they can be used for other purposes, such as biological weapons, right? And so even though they might have uses for pharma or cosmetic industry, you name it, the US government controls them very heavily because they can be used for other purposes. And for that reason, those items would be deemed to be a critical technology. And then finally, the third category of critical technologies, another new definition, emerging and foundational technologies. And this is a new form or a new definition of technology that emerged in conjunction with the legislation that President Trump passed into law in 2018. There are a number of, significant number of US businesses that are actively involved in the development and manufacturing and research of emerging and foundational technologies. These are new, innovative technologies, in many instances that the US government has not yet had the opportunity to review and to classify them as items that are controlled under the export control list. And because of that, those technologies are not subject to export controls and then wouldn't fall under that first bullet of critical technologies. And so what FIRMA did is it charged the US government through the Department of Commerce to figure out what categories of emerging and foundational technologies are of interest from a national security perspective from the US government, and then assess whether those technologies should be added to either the Export Administration Regulations or the International Traffic in Arms Regulations, which would then kick them up to the definition of critical technologies. One of those categories that we have seen be defined as emerging and foundational technology are biotechnologies. And you'll see here there's a list of several that have been identified as categories of interest: nanobiology, synthetic biology, particularly genomic and genetic engineering is something of significant concern to the US government. I can say at this stage, the government, as they have defined these categories, has been slow to roll out a list of those types of technologies that should be controlled for export control purposes, which would then kick them to the level of a critical technology. So oftentimes what we see in the biotech space is, a company might be involved in the development of very pioneering genetic engineering, but those technologies are not controlled on the export control list as of yet. And so there's a conversation between council and the companies and the investors as to whether the fact that it's just a biotech company, bioscience company that is involved in these emerging technologies is enough to check the box of a national security data point that the parties should consider as they're reviewing whether or not to make a filing. Next slide, please. So here is sort of a summary of what we would consider sensitive personal data. For a long time, the US government has been very focused and very interested about foreign investors who are engaging in legitimate commercial transactions that provide them with significant access to sensitive personal data on US citizens. The Department of Justice is one of the agencies that sits on the interagency committee at CFIUS. It's one of the 9. And the Department of Justice has very vocally and publicly stated that the collection of sensitive personal data on US citizens is considered to be one of the biggest national security threats by the US government, and certainly by the DOJ, as it's investigating different types of data breaches, hacks, you name it. They are concerned about foreign actors being able to just take an amass amount of data on US citizens from various transactions, perhaps combine them with information that a foreign government actor has obtained through a data breach or a hack, put all of that information together, not just about me per se, but my family, my friends, my coworkers, people I went to school with, provide sort of a holistic set of data that a state actor or another entity or individual in a personal and private capacity could use in a manner that is harmful to US national security. So with FIRMA, the US government provided for the first time some scoping around the types of data that they are concerned about the collection of data around. Patient identifiable data on genetic tests, information on the physical, mental, psychological health condition of an individual, information that you get through biometric data, information that you might get in a health insurance application. Those are the sorts of data points that CFIUS is most interested in from a perspective of what is a TID, the D part of that acronym. There's some thresholds for much of this data. For instance, the second, third, and fourth bullet, you need to be a business that collects records of 1 million persons or more, or has a business strategy to perhaps in the future collect information on 1 million US persons or more. That is, in this day and age, that is not a hard threshold for companies to meet from this perspective. So critical technology, critical data are certainly extreme focus of the US government. There's still interest in critical infrastructure, which is really on energy assets, satellites, communications, different telecommunications company, but those is a more narrow, the eye is a more narrow swath of industries, and technology and data is of significant concern, I would say, to some degree more than the infrastructure points. And then moving on to the next slide. So this slide is just intended to provide some context about the different types of considerations that CFIUS goes through when it's trying to determine whether a transaction rises to the level of a national security threat. It looks at 3 issues, sort of the threat, whether the foreign investor has the capability or the intent to cause harm, the vulnerability, whether the US business, whether it's through its industry, the types of technologies that it develops through its connections to the US government, does having a foreign investor in control or have access to certain types of data create vulnerabilities from a national security perspective. And then when you have the threat and the vulnerability, looking at those together, what are the consequences to US national security? And so when we're looking at transactions and investments, trying to decide, primarily what in your, if you have a mandatory filing, you have a mandatory filing. And unless you reconfigure or recalibrate the way the transaction happens in terms of rights, you'll have to make a filing. And there can be discussions about when in the process to make a filing. But when you are dealing with a voluntary filing, there are really a lot of considerations that you have to look at, both from the foreign investor point of view and from the US business point of view. And that is what we have here in this slide, sort of looking at the key considerations with respect to who is the foreign investor, what country are they affiliated, have they been to CFIUS before, what has CFIUS's reaction been to prior investments and transactions, what is the scope of the US business's technology, do they have direct or indirect connections or nexus points with the US government, particularly those agencies that provide what we refer to as homeland security responsibilities, notably DoD. Will there be supply chain disruptions if a foreign investor acquires control over them? And so it's sort of putting together a puzzle to kind of assess what the national security implications of a transaction are, and helping to determine whether we think a filing, even though it's voluntary, should be made because we think it's the kind of transaction or investment that CFIUS would be interested from a national security perspective. Next slide, please. And as you'll see here, kind of outlines some of the key questions that we ask on the foreign investor and the US business side. Some of them I've already walked through the course of this discussion, but this is really intended to just lay out how complicated the analysis can be, because, regardless of how long the regulations at their core are, or sort of the guidance that CFIUS puts out with respect to how to make these assessments, this is a committee that has unfettered discretion to ask questions and to make assessments about foreign investment in the United States. And so it's really important when you are putting together sort of a decision matrix, whether to make a filing or to not make a filing, all of these general questions are asked and answered. In the event CFIUS, through this non-notified unit, does come and ask questions, you've got the answers to the questions already. You've already gone through the process. And then it's really focusing on making sure that CFIUS understands the answers to the questions, that you're able to very promptly and efficiently answer any follow-up questions to hopefully get CFIUS to understand in the situation where a filing was not made. And oftentimes filings are not made for legitimate assessment reasons. From a commercial business perspective, a CFIUS counsel working with a foreign investor or a US business, both parties decide with the recommendation or advice of counsel that a voluntary filing is at play, but no filing has to be made. If CFIUS comes back, we might put in cooperation provisions in any relevant investment or transaction documents, so the parties are cooperating if CFIUS does ask. But sometimes, the definition of national security from the government's perspective changes and evolves, even as we have these parameters. So it's just important to go through all the considerations, to go through the diligence, and just be prepared in the event CFIUS comes to have a good explanation and story as to why no filing was made. And then finally, just clicking to the next slide on key considerations. One more, please. Thank you, Christina. In terms of looking at where we are now in the landscape from CFIUS's perspective, it's changed dramatically. There's no doubt about it. Even though the committee is still maintaining its focus on transactions that do raise national security, interests, or do put national security interests at a bit of a vulnerability. The jurisdiction expansion to non-passive, non-controlling businesses has really changed the landscape. Many more transaction investments can now fall under the scope of CFIUS's review than any time in history. And because of that, companies and foreign investors have had to pivot off of what has historically been a very safe space in terms of analysis. Is this a controlled transaction? If it's not a controlled transaction, CFIUS doesn't have jurisdiction here, I'm good to move on. Now you really need to look at the types of rights that a foreign investor may be obtaining. If they're obtaining the access to non-public technical information, the substantial business decision-making, or observer or board seat rights, you really got to dig in and see if the US business would be considered a TID US business. Next slide, please. And then here are some of the kind of what I call industry-specific risk factors when you're thinking about technology, biotechnology, life science, bioscience companies. The key risk factors, again, are you dealing with critical technology? Is it a company that deals in or collects or maintains large volumes of sensitive personal data? And then you have to look to see kind of what are the rights that are being obtained, and what are the different sort of commercial or transactional arrangements that the foreign investor might be getting these types of rights or opportunities with respect to the US business. Before FIRMA was fully put into place, CFIUS, or sort of the Congress, actually wanted to give CFIUS even broader jurisdiction than FIRMA gave it. It wanted to give CFIUS jurisdiction over licensing agreements. It wanted to give CFIUS jurisdiction over non-US joint ventures. That was scaled back dramatically, and thankfully, because those types of commercial arrangements are ones that go on each day, every day, particularly in the bioscience, biotechnology space. And there was a concern from industry that there would be a chilling effect on investment in the United States if these different types of commercial arrangements were picked up through the CFIUS process. So moving to the next slide, CFIUS does not have jurisdiction over specific commercial agreements or transactions, such as licensing agreements or joint development and marketing agreements. Those do not generally implicate the CFIUS regulations. However, it's important when you're putting together those types of commercial arrangements to assess whether there are any rights in there that would perhaps provide a foreign investor or foreign partner with control, or provide these types of rights, particularly around substantive decision-making, which is a pretty broad definition, even from CFIUS's perspective, to just ensure that there's no nexus point to the CFIUS jurisdictions. But traditional licensing agreements, joint development agreements, generally are outside the scope of CFIUS's jurisdiction. And I think we're often able to get very comfortable with that type of analysis, but it's just important to kind of do that double check to make sure there's not a hook there, or there's nothing that's sort of unique or non-traditional about the arrangement that perhaps could create an avenue for CFIUS to come looking or knocking on the door or ask questions. And then finally, moving on to the next slide, which I believe is the last slide, is joint ventures, which I kind of just alluded to, especially in different types of technology industries. Joint ventures with foreign investors are a key, important commercial relationship. So if you have a joint venture that you're setting up exclusively outside of the United States, generally not going to fall under the scope of CFIUS's jurisdiction, and the US business and the foreign partner can engage in those activities outside the United States with very little fear that CFIUS can assert jurisdiction. But one thing to keep in mind in terms of joint ventures is if you have a foreign party entering into a joint venture in the United States, looking to see what the US business is contributing to that joint venture. If the US business is simply contributing some technology, some licensing agreements, not enough material assets to constitute a US business, I would take the position that that would not be subject to CFIUS's jurisdiction. But we've seen situations where the foreign investor is providing all sorts of capital and the US business is providing itself as sort of the counterpart to the capital that the foreign investor is providing. In that situation, if the foreign investor is able to obtain control over the US business that's being contributed to the joint venture, CFIUS would have jurisdiction. Doesn't mean that a filing would be required or mandatory, but you'd want to go through that analysis. And even if you find that a voluntary filing is at play, the decision may be to not make a filing. And that reasoning should be documented and thought out thoroughly and comprehensively, whether the filing is going to be made with respect to the joint venture. But if you have a foreign investor who is now going to have control over the US business through this joint venture operation, that joint venture, even though it's based in the United States, would be considered a foreign business for the purposes of any other subsequent transactions or investments in the United States. And so oftentimes we do see situations where the parties are just saying, oh, we're getting into an arrangement with a US joint venture party, and then through sort of diligence around the joint venture, we come to learn that the actual partner, the JV, is actually owned or controlled by a foreign investor. So that business that another US business is looking to get into a transaction with would be covered from a CFIUS perspective. And then you've got to go through that analysis over again in terms of whether a filing should be made. So I'll just end by saying, the landscape has shifted. CFIUS certainly has a broader jurisdiction than any point that it has ever had. CFIUS continues to focus on national security concerns, but those concerns are broader. Those concerns are growing and they still continue to evolve. And, clients often ask, is CFIUS, if I have to go through CFIUS, does that mean my transaction won't clear? The US government will not allow me to engage in these types of transactions? That is certainly not in the case. Most investments and transactions that go through the CFIUS process are cleared. Most are cleared without mitigation. But if some of the boxes that we went through are checked, it's certainly important to confirm that we don't have a mandatory filing and that we don't have a broad range of national security interests of the US government implicated, such that a filing would be warranted.
Emma, we do have a question. Could you give us an idea of time and expense to go through the CFIUS review process?
Yes, so the time and expense depends on the type of filing that you're going to make. One of the changes in the regulations is that you can either make a long form filing or you can make a short-term filing. So if you make a short-term filing, that usually takes about, I would say, 7 to 10 days if the parties are working efficiently to kind of put that together. CFIUS has 30 days to review it. And at the end of that 30 days, they can clear the transaction. They can say, there's nothing to see here. We're still going to maintain jurisdiction, but you can go ahead with your transaction. We're not going to prevent you from doing it. Or they can ask the parties to come in for a full filing. There's no fee associated with the short form filing, so that can be attractive to both parties because there's no filing fee. But the downside is if CFIUS does determine at the end of that 30 days, you need to make a long filing, you then need to go through that second process. In terms of the long form filing, that is much more extensive collection of information on both the US business and foreign investor side. So we typically see that it can take anywhere from, on average, 3 to 4 weeks for the parties to pull that together. Then you submit a draft filing to CFIUS. They review it, ask questions. You've got to incorporate the answers into those questions into the final filing. And then that is submitted for CFIUS's starting the clock of their review. They will say, you may now submit this once you answer these questions. That starts the 45-day review clock. At the end of the 45 days, CFIUS can clear it, or they can ask for an additional 45 days, which we call an investigation stage. So that could take you up to 90 days. And then in extraordinary circumstances, they could ask for another 15 days. to review the transaction. The benefit to the long filing is at the end of their review or investigation, they have got to make a decision. They either clear it or they say, we're going to block it or we're going to unwind it. They can't shoulder shrug. And then there's a fee, sort of outside of your counsel's fees to put together filings. With the LongForm filing, there's a fee that is submitted to CFIUS, which, depending on the value of the transaction, could be $0 or all the way up to $300,000, just depending. That $300,000, I believe, is for investments that are $750 million or more. So that's at the upper end.
Mm-hmm. Well, thank you so much, Emma. We're at the end of our time, but if there are additional questions or topics that people have, feel free to paste those into the chat and we can follow up after the session or via email. Again, thank you to Emma, Brigitte, and the Montana World Trade Center and Montana Department of Commerce, Export Montana, for partnering with us today. A recording of the presentation will be available on our website and also emailed out to everyone who registered. So thank you again for joining us today.
Thank you.